saw Mr. Lynch about 1 minute
Okay.
ago. Yeah.
Please have your appearance on the record.
Stephen Lynch, from the Vice President.
All right. Is the report factually accurate?
Your Honor, there are some corrections that we would like to make.
Okay, now, not as to guidelines, because I did not receive anything on that, but what would you like to make?
Well, I still was going to address just one of the guidelines, but starting, if the court were to flip to page 2, at the bottom it indicates under personal history, substance abuse history, it says yes. Obviously, there's no signs or anything in the report relative to any substance abuse history, so I would ask that that be no.
Do you object to changing that?
No, Your Honor.
Okay, we'll make that no.
If the court were to look at what would be page 2 under the evaluation plan, so it's about the 5th or 6th page in. At in the first line of that first paragraph, at the end of the sentence it indicates the victims to contribute to his fraudulent investment operation known as. Why does we strike the his fraudulent investment operation known as? I think that's just the probation officer's own terminology. So it would just read contribute to pay it forward. It's the first and second.
Okay.
I would ask
Strike
that
that.
be stricken.
Yes.
Yes. And then in the end of that paragraph, Judge, the last sentence starts with there were several images
Yes.
viewed by the defendant. I would just ask the language viewed by the defendant. There was no testimony necessarily that he viewed it. There was testimony, obviously, in the prosecution's belief was that he possessed it. And that is the ultimate conviction, but there's nothing to suggest that he viewed it.
Your Honor, I think inherent in statute is that he viewed it. I mean, they're temporary internet files, which means they were opened and viewed.
Say viewed, strike by the defendant.
Thank you. The only other one in the next paragraph really just discusses the only OV that we had an issue with, and it would relate to the larceny by conversion was predatory conduct.
Okay.
They had scored 15 points. Now, they've noted in the report here that they scored 15 points due to Mr. Skupin contacting the victims, Peggy Sue Breland and Renee Cuccetti. In the reports, and at least the police reports that I reviewed, and I did pull them again, yes, there was a phone call made to the individuals, but I don't believe that that rises to a level of predatory conduct such that 15 points should be scored there. Simply making a phone call, I mean, we more think in lines of, unfortunately, like in the lines of a murder, where you lie in wait, or you keep stalking a person, or keep going after a person. There was a phone call, at least according to the reports of these witnesses, but that doesn't make it predatory.
Your Honor, I think he used his, in fact, I know he did from his website, he used his minor celebrity status to persuade people to give him money. And I think that had he just been a mailman, that wouldn't have happened. I mean, I think he preyed on people based on who he was.
I think he used his celebrity status to prey on people, and I think it's properly scored.
Judge, the next line, just still on that same page, it says restitution is requesting amount of $38,100. I think it should be $31,800.
Okay.
I think that's just a
That
typo.
change will be made.
That's correct.
Am I correct that $10,920 has been paid?
Yes, and I have the receipts.
Yes,
Okay.
Your Honor.
So that's the 1/3.
That's correct.
Okay.
Your Honor, if the court were to look at page 14,
Yes.
the fifth paragraph down starts, I'll have about $50,000 of debt. Does the court see that paragraph?
Yes.
Okay, in the second line that says, with bail bondsmen, attorneys, and living expenses, just so the record's clear, I'm court appointed, I've not been paid anything in this case, so I don't want there to be any appearance of impropriety that I somehow received anything. I just didn't like how that read, I just wanted to know
Okay.
for the record.
You are court appointed. Technically, there is money owed to you.
Eventually, but I haven't received
Okay.
anything as that would.
All right, we'll strike it because of the way it reads.
the court were to look at page 21,
Right.
where it says Christopher Shelton under family, it says brother, that should be other family, and it's Christine, not Christopher.
Thank you.
And then below that, it has Leo Christian Skupin listed, other family, that's actually his son.
Okay.
That needs to go. Then that needs to
Not
go.
other family, it should be son.
That's his son, so I guess it would go on the next page under the marriage paragraph.
All right.
On, yes, Leo is the son, right here. That's Christine, and it's other family, not a brother. One moment here, I'm just letting probation catch up.
Okay.
Christine. Okay. You're on the next page, under marriage.
Yes.
Second name from the bottom should be Tina, not Tura,
Correction will be made.
and that's fiance. And then the very last name, Remy Waldron, is incorrect. It's the last name is Appelt, A-P-P-E-L-T, first name Penny, P-E-N-I.
All right, thank you.
Almost done, Judge. On the next page discusses the substance abuse and treatment, page 23.
Right.
Again, there it says the start date of 1/1/83. He never told them the start date, and again, that supports my position that there was no substance abuse history, but he never told them the start date of that. It's infrequent, but I just want to note it for the record.
Okay. Start date unknown.
Well, he did. He done ages.
Oh,
That's where we get it
that's
from.
because age 21.
He did give us an age. That's where we get it from.
Thank you. We'll leave it.
Page 24. Similar to my previous comment relative to attorney fees, Judge, if you look at court order payments, it says $10,000 legal bills. Just so it's noted again, on court appointed, I have not received anything.
Is there another legal bill involved with
Well-
somebody else?
No.
Okay.
All we did is take from what he listed, so.
All right.
But I want to note that I haven't
Okay.
received anything since I'm court.
Well, I think it should say court appointed approximately.
Well, trust me, it's not going to be $10,000.
Okay.
You want to remove?
Court appointed fees.
Do you want to take the amount out?
Yeah,
Yeah.
because I haven't received anything.
What is it?
Well,
Your Honor, as it relates, I guess those are the only corrections.
Okay.
I did review the AG's sentencing memorandum as to guidelines. I don't know if she's going to address any of the guidelines or just
all right,
leave it as is.
my understanding is the guidelines on the count 2 are 5 to 23,
That's correct, Your
and
Honor.
on 7 to 10, 1 to 17,
0.
0 to
I
17?
hit 2 to 17, Your Honor. I scored predatory conduct, and
Okay.
that's how I got
Well-
to 2 months to 17.
I don't know if the predatory would apply in the, are you talking about in the CCM counts?
On the CCM count.
The larceny count is 5 to 23.
Yes.
Yeah,
CCM probation has them at 0 to 17.
I have them at 2 to 17.
So you score the predatory.
No, she scored. The only other difference, Your Honor, as an officer of the court, I would
I
indicate
scored-
that OV9 should probably be 10 points.
I'm sorry, that's a correction, vulnerable victim, excuse me.
Would that make a difference?
If, as an officer of the court, I would indicate that that would make them, the total OV is 35, they would then be 2 to 17.
Okay.
That's correct.
So the OV9,
So-
not the
OV9 would be 10.
Yeah.
That's correct.
So as an officer of the court, I would indicate that.
Thank you, Ms. Jones. All right,
Yes, that's right.
Change
2
will
to
be
17.
made.
Yes.
so it's 5 to 23, 2 to 17.
Correct.
All right.
May I
Yes.
continue the elocution? Are there
Are
any
there
other
going to
corrections?
be any victims speaking?
Not to my knowledge, victims are, there are some present, Your Honor, but
Okay.
they did not wish to speak.
All right.
May
Please
I
go
continue?
ahead.
Your Honor, obviously the court had an opportunity to review the PSI from my client's really lengthy comments that he shared with the probation department when he met with them. I did obviously have a chance to review the AG's commentary, and part of my concern in her request of this court is, I will tell you, I instructed my client not to say anything to the probation department. We have an appeal pending. As the court knows, there was a stay that was denied right as we were picking the jury in this case. Those matters are still pending with the Court of Appeals. He pled no contest on the larceny side. I instructed him not to say anything at probation. So to hold that against him...
Well, didn't he say something?
Well, he did say some things, but...
lengthy statement.
He did, but the Attorney General took issue with the fact that he did not express remorse, admit responsibility.
Well, he expressed.
And as an officer of the court, I'm telling you that I told him not to. That was my advice to him because of those issues pending with the appeal. And it appears to me at this point that her request for a 1 to 4 sentence seems to want to punish him because he didn't say certain things. And, you know, obviously he still had a right to trial. He exercised his right to a trial. We do have an appeal pending on those issues related to the search warrant. Your Honor had entered into a Cobb's evaluation on the larceny the day that he pled that if he paid $10,000 towards restitution, he would get probation on that count. He did do that.
I'm honoring that.
So I guess what we're talking about then is the second issue.
Yes.
All along, I mean, obviously my client has no criminal history. I think that his payment of the $10,000 has shown this court that obviously he will take this court's orders seriously. I don't think anybody here has ever necessarily seen him as a threat to society. He has the ability to make money and to repay the victims as he's already demonstrated, or at least attempt to. Some of the restrictions as included in here, like paragraph 8, I don't see how that's rationally related to anything as far as alcohol and drug use. There's no issues with that. I don't know if that's necessary. I would ask the supervision fees to be lowered because he was suspended for a period of time, so I'd ask that those be at $10 a month. The real concerns I have, Your Honor, are kind of laid out in the what would be page 2. It's actually the 3rd page of the report, where you talk about like paragraph number 2, where you can't live in a house where there's internet or anything. In this day and age, that can't occur. What I would suggest to the court is this, and even with employment, we would ask you to not include those types of restrictions because in this day and age you can't work without being able to use the internet. A lot of his work is related to that with the visa sales and the things that he was doing. He would, if necessary, if you want to bring in his computer so that the probation department can look at his history every time he meets with them. And they can go through it that way if necessary. But to shut him down with any phone, computer, internet use, is it effectively making him unemployable? In which case, then your complaining witnesses will not be reimbursed because he can't make a living. The other concern I had is on paragraph 5, student safety zone. He's over the 1,000 feet. That's not so much the issue, but he does have several what would be stepchildren. Once he marries, he and his fiancée get married, and he has still school-age children that he would be allowed to attend legitimate school functions. Obviously, there would be other adults there. It's not him. And there's no concern that he was loitering or doing anything improper at any of the schools. Some of the
What
victims...
number is that?
Pardon me? That was number
1.6, Your Honor.
Or number 5 under the page 2 that I was referencing.
All right.
In line with that, Your Honor, is under paragraph 1 talks about contact with children under the age of 17. The home in which he lives, there are 2 children, his fiance's home. Again, I don't think there's any concern that he's having any...
Your Honor, I don't know if that's true or not true, but I mean the same rules that apply to everybody else who's convicted of this type of offense should apply to Mr. Skupin. I mean, I do have some concerns about the children that he's living with. I don't know if he's at risk because he won't admit any responsibility, participate in treatment, see a therapist, make the information available. He has been throughout the entire case, and as far as I can see, is still only concerned with himself.
Well, if I may finish?
Sure.
Thank you. For for the prosecutor to say that there is absolutely no evidence to suggest anything along those lines, what I was going to suggest to the court is any orders you make as to visitation or supervision or his presence of children, there is an ongoing civil proceeding, that
Okay.
any order should defer to that. And that he...
In the family court?
Correct.
Okay.
And that, as it is now, his bond condition is that he not have any contact with a child under the age without some other adult supervision, or at least another adult present. And I've just asked that that continue. But for the prosecutor to suggest that therapy and things like that, he hasn't been ordered to do any of that at this point. The only other concerns that I have, Your Honor, there's a request for no contact with 3 people that are not complainants. The last 3 names listed on the face page.
Yes. What
2
about
of them, they are friends. I don't know if that's necessary. I mean, obviously, we have no objection with any of the listed complainants.
But you mean the last 3 on the list?
Mitchell, Nolan, and Walter. I mean, in their, they don't seem to say anything along those lines in the commentary that they gave the probation department. So we would ask that they not be included.
Do you know why they're listed?
I don't, Your Honor.
Okay.
So having said all of that, Your Honor, at this point, we would ask the court to consider the following. Obviously, this is my client's first convictions for a felony offense. The jury found him guilty of 4 of the 6 counts. Although we respect the decision of the jury, I know the court sat through the trial. My client still maintains his innocence and is going to seek appeals relative to that. He is in a position where he can try to make these complaining witnesses in the larceny whole. The court did offer a COB on that if he paid $10,000, which he did, to probation. We would ask that the court also impose a probationary sentence. I realize there's no COB on the CSAM charges. As it relates to that, it would be 5 years of probation pursuant to statute. Set up a monthly payment plan. Make him pay $1,000 a month, $1,500 a month, so that these individuals get paid off. I think to run in now when the search warrants are executed at the end of 2013, we didn't try this at the end of 2016, and to run in now and wave our hands around and say he's such a threat and such a danger. They sat on these things for over 2 years before they ever did anything with the computers. So once they found him, and then it took some time. But to run in now and claim that he's such a threat to everybody, I don't think that that's necessary. He hasn't shown himself to be a threat. He's lived 54 years of his life without that being the case. So I would ask the court to impose a probationary sentence with a payment plan and hold him to it. Or if you want to impose a jail sentence, well, you can't on the CSAM and delay it, I was going to say, but I would ask you to let him continue doing what he's doing, paying off these victims, and keep him under your watch for the 5-year period. Thank you.
I'm going to let Mr. Skupin speak, but would you like to speak first?
Just briefly, Your Honor, I'll keep it short because I did a sentencing memorandum, so...
Which I read.
I'm sure you did, Your Honor. So obviously, we're asking for 1 to 4 years MDOC. Biggest thing that is of concern to me with Mr. Skupin is just the way that this entire case has been treated. The reason why it didn't get tried until 2016 is there were numerous motions and adjournments and appeals to give Mr. Skupin an opportunity to fully try his case, which he absolutely did fully try his case. And he took the stand, he tried to put that responsibility onto his 17-year-old stepson, which I personally find pretty appalling. Child sexually abusive material, the possession of that, the viewing of that is like an addiction. And for him to not take any responsibility, I know he's seeking an appeal, but that doesn't mean that he can't go in there and say, hey, I'm going to do treatment and therapy and show you that I'm serious about recovery. And I'm still doing an appeal, so I'm not going to talk about the specifics of the case, but I'm going to get the help I need to make sure I'm not a risk to kids. I don't see any of that, which in almost every one of these cases I do, people come in with a big thing from their therapist, look, I'm in treatment, I'm getting help, I swear I'm not a threat. I think he is a threat. I think he's a threat because the only person that matters to him is him, and that ego gets in the way of him viewing other people, children, his stepson, the victims of his financial crimes, as like actual human beings. So I think 1 to 4 years MDOC is appropriate, and that's all I have to say. Thanks.
Thank you. Mr. Skupin.
Thank you, Your Honor. I see all of this as very serious, and I think this is a very serious case, and I've never, ever, ever denied going to a treatment place or talking to a therapist on my own dime. I would gladly do anything that the court wanted me to do that they thought was fit, or that you thought was fit. I never, ever said who, what, when, where, why these pictures were on there or viewed. I just maintained that I didn't do it. That's all I maintained. I wasn't pointing the finger at anybody. There was hundreds of people that use these computers. But I have 11 children that I'm raising, and 4 of them are at-home minors, and 4 of them are in college, and I have about $1,000 a month obligation towards child support, and there's so much fallout that would result in me going away. My children's mothers, they wouldn't get the money. The complainants, I am very serious about any order that the court gives me. I have done everything so by the book since the day this started. I have maintained. I showed up early. I made every appointment. I made every phone call. I did everything that I was asked to do. I am not about me. I'm about following the rules. I'm almost 55 years old, and other than a few minor traffic altercations, I've never ever been charged or had any contact with law enforcement ever. My brother was a police officer. My father was a police officer. I understand the process. I would just ask that in order to maintain the quality of my children's lives and raising children, and there isn't anything that I wouldn't do that you guys asked me to do and I wouldn't take very seriously. I bringing a computer in if I had to, or showing up however often I needed to show up, or going to whatever places you thought I needed to go to for, just to make sure that I understand the seriousness of everything. I really, really do. I spent a year deeply sorry for everything, and I just ask for the mercy of the court. Probation, I would follow any rules, any term, any length, any amount of time. Anything that you asked me to do, I would gladly show up, or I would gladly show up early. I want to make it right. I want to make it financially right. I want to make it socially right. I want to do everything the right way. And I would ask that you give me the opportunity to do that.
Thank you. All right. The court has reviewed the report. I know 1/3 of restitution was to be paid by sentencing to avoid jail on count 2. It has been paid. You have 6 prior misdemeanors for vehicle offenses. You're divorced with 5 children. You have a bachelor's degree in business management from Western Michigan. You had established Michael Skupin Ministries in 2002. You had been speaking throughout the world. Currently, aside from selling your assets for your support, you have worked as a consultant in construction and various other jobs. In fact, you say you have 15 sources of income. You reside with your fiancé in Milford. One of your offenses involves a fraudulent Ponzi investment scheme called Pay It Forward, where you would solicit money from the victims while promising large returns on their investments. You accepted responsibility and pled no contest to that offense. You were convicted by a jury on 4 counts of possession of child sexually abusive material. You had one of your children testify on your behalf. And in fact, part of your defense was casting suspicion on your 17-year-old stepchild. Your own lengthy statement regarding your criminal activity was disturbing, and it shows a lack of remorse or acceptance of responsibility. Not only did you exploit the child victims whose pictures you surveyed? But you also involved your own child and stepchildren in an attempt to reduce your culpability. It is the sentence of the court on count 2, larceny by conversion, $1,000 or more, but less than $20,000. 4 years probation, 8 days jail, 8 days credit. This is where restitution, as ordered by the court, 1/3 was paid. As to counts 7 through 10, possession of child sexually abusive material, for the reasons the court has stated, the court is exceeding the advisory guidelines somewhat because of the trial, not going to trial, but the method of the trial, the defense of the trial, but most particularly the statement, the building up of yourself and your good works, which the court finds offensive in view of the children that have been exploited in this case. So it is the sentence of the court that you shall serve 1 to 4 years, Michigan Department of Corrections. Jail credit is 8 days. Restitution, $31,800. Part has been paid. First money goes to restitution. Supervision fee, $1,440 and $30 a month. Court costs, $500, attorney fee to be determined. State costs, $340. Comply with DNA testing. During your probation, you shall submit to alcohol and drug testing as directed by probation, not use any controlled substance without a prescription, maintain and/or seek employment as directed by probation, income withholding order to enter on verification, comply with sex offender registration requirements, maintain and/or seek employment as directed by probation, income withholding order to enter on verification, no assault or threatening behavior, not use or possess a firearm or other deadly weapon, no contact with Kira Worthington, Shirley Morris, Mark Ruggles, Clark Justin, Nabil Beydoun, Shelley Parsons, Dale Cassidy, Renee Puccini. In addition, no internet access except for work purposes. Visitation with your minor children as set forth by the family court and coordinated by the family courts. That is the sentence of the court. Mr. Lynch will hand a form to you if you wish to appeal. Please return it. I will process an appeal.
Your Honor, we are signing the appellate rights form right now, which I'm going to hand to your clerk, and obviously for the record, we would object to the court's deviating from the advisory guidelines so that that's preserved.
There is a
Yes.
DNA cost of $60.
Okay.
And also in regards to part of the sex offender registration is the safety school zones. That's part of the registration. So
That is ordered.
Okay,
This
thank you.
I'm handing
All
this
right,
to
I'm
the-
going to take a 5-minute recess.
Please rise. Have a seat. Thank you.